Your Honor, Everdale v. Everdale is also one of these, but it was a presentation when Judge Evans took over. I'm guessing we're going to need to set that over. Amy Powers is here today as well. I did see her.
I'm here, but I believe Judge Bashor heard the motion and is the one we should be having presentation in front of.
Oh, my apologies. I have Judge Evans down on my list, but now I remember. My apologies. I'll go back to where I was.
Yeah, we could go ahead and take that one. I thought I am not seeing that order, but I thought I had seen one.
The court actually wanted additional information and supposed to be following up on the court investigator and then getting additional financial orders from Your Honor.
Okay.
And just so Your Honor is aware, it appears the child is on the hearing. The child is 17, turning 18 in 2 months. I believe he told his father that he wanted to have a voice here today since where he's staying is at issue. I just wanted to disclose that to the court. He did want to speak. I'm not his attorney, obviously. I just heard that through the grapevine, and I do believe I see his name there.
So this matter, you still want to go ahead today, is that correct?
Yes, my apologies.
Okay.
Yes, I do as well.
Okay, so we'll come back to that in just a minute here.
Anderson v. Ericson should be very, very quick because there's no response.
Right here. And the response.
This is Anderson and Ericson. All right, man, if I can have you come up to the table there. That's fine. Just you can get there right by one of the microphones.
I figured there wasn't much time, so I just.
If you sit by the microphone, just down one seat, so it gets on the record. And you're Brittany Ericson?
Yes, sir.
Okay, so what matter was, yeah, so I look at this one and Ms. Wickles, did you want to make any comments on this?
Yes, this is a strange one. We had a trial, and the trial judge was Judge Fassett, and she gave mom the additional 6 months time to do some evaluations, new evaluations, and to prepare them before essentially any visitation occurred, minus professional visitation. It's been a lot longer than 6 months. Nothing's been done. There's been absolutely no visitation, no professional, nothing. So we submitted this in order to make that, it was a quasi-temporary order. The judge said, we'll revisit this in 6 months. If nothing's been done, this is final. If something's been done, then we can amend at that time. Again, it's been longer than 6 months. Nothing's been done. We filed this, we gave notice, and I'm kind of shocked Ms. Erickson's here because we have not heard anything. There's been no new evaluations. The only eval that was submitted was the one that was submitted initially, which was a very old evaluation, which the court said needed a brand new one. So I'm asking that final order, that quasi-temporary order of the trial be entered as the final order, and that we can work from that. Because right now we don't really have a quote unquote final order. And this is just to essentially certify that trial order.
Well, two things. There is a final order in the court file. It was filed on December 19th.
If you go
different than the one that you presented, and that was entered by Judge Bassett, it doesn't provide for an automatic modification of that order.
Is that order really final? Because if you go to the visitation, that's the question. If that order is final, we're good with it. But there is, it appears that Ms. Erickson could modify that within the 6 months.
Yes.
And that was where the confusion kind of came in.
Maybe.
I guess this is going to be put on before Judge Bassett because this appeared to me to be a modification of that order, pretty significant modification. Based on a relocation order, which was not appropriate based under that methodology. So if there's something else that Judge Bassett's aware of, that can be noted back in front of her.
Okay.
But this is a gigantic change over the ordinance in the file.
Okay, and that's why it was very confusing, because that was what was said at trial if nothing occurred. So we will renote this in front of Judge Fassett, and she can figure out what she wants to do with it.
Does she have a presentation docket? My thought would be is to just put it onto that docket. You can all talk with her, and then if she needs to have more time set, she can then order that.
That would be great.
Yeah, we'll put it on for next Friday, not this coming Friday, because apparently she's in trial this Friday. So it'd be the 6th of September at 8:45.
And that works, and that gives me enough time to get those.
Yes, and that is a Zoom hearing. So if you need access to Zoom, we do have Zoom booths here in the lobby.
Cool. Thank you.
Okay.
Okay, thank you, Your Honor.
We have all the parties here.
Yes, Your Honor, it appears everybody's here.
All right, what's going on?
Yes, Your Honor. I'm not sure if you remember this trial. It was a while ago. We had a final trial, and Your Honor ruled on a temporary parenting plan to see if Ms. Ericson would get an evaluation. And that if after a period of 6 months she didn't get the evaluation, we would make a permanent plan. And Your Honor gave us some ideas on what that plan would look like. It's been longer than 6 months. There's been no evaluation done. Nothing has changed. In fact, Ms. Ericson has had no visitation with the child at all. In that time, I'm not sure quite how long it's been, but it's been a while. So we're asking for a final plan to be put in place just so there's not that temporary issue, so the parties know what their rights and obligations are going forward. If it's not the plan that I wrote, that's fine, as long as we have something final. And I don't mind if Your Honor wants to take it under advisement and maybe review, because I know it was a long time ago, or if Your Honor wanted the transcripts and just to email us what Your Honor decides, that's fine with me as well.
All right, so there was limited contact allowed with conditions. I'm looking at the parenting plan that was entered in December of 2023.
Yes.
And there needed to be an ROI with an additional evaluation. And if she did all that within 60 days, she could motion the court for a change of the parenting plan without an adequate cause finding. And so it's been obviously more than 60 days for that. And it's been 6 months and nothing. It doesn't appear that anything's been filed by Ms. Ericson. And Ms. Ericson, have you filed anything in the last 6 months in order to get visitation in this matter?
Yes, I actually had the assessment done. I have it I have the copy right here. I have had contact with my daughter on video. What has happened was I got the assessment done actually 2 days after the court hearing. I was able to get in as quickly as I could. Right after that, I ended up getting the flu, got really, really sick. And then in February, the 1st of February, I had called Ms. Winkle's office and asked if that was all I needed to do, because I don't have representation. I did. And he completely just left. Scott Roberts just up and left with a different law firm. Anyways,
but
so,
wait, here's a question I have for you. I'm going to interrupt you, and I apologize, Ms. Harrison, but you said 2 days after the hearing, you got an evaluation. That was supposed to be a collateralized evaluation where the GAL and Mr. Anderson were able to weigh in on that. Did that happen?
Yes, it did. It has his input and everything in it.
If this happened so long ago, why didn't you file it with the court as ordered?
So what happened was, in February, when I went to go, right after I had called her office, I had noticed, because I got a email over my daughter's medical saying that she had a doctor's appointment. I go into her My Chart, and Mr. Anderson had changed my name out completely, like he was the one that gave birth to my child, deleted me completely out of her medical record. And then
you're getting completely aside. Why did you not file your evaluation with the court as you were ordered to do so? I don't care what anybody else did. Why didn't you do that?
Because so I was also trying to get help through Northwest Justice. I had been blowing up their phone.
You clearly filed things before. So why did you not take that evaluation and file it with the court? You filed other things last year. So why did you not file this?
I was, because of everything happening. And then I was upset. I didn't know, like him taking me out of my daughter's medical, him changing her name. It started to really mess me up. And I called Northwest Justice trying to get representation, trying to get help. And they sent, I guess I didn't have the right cover letters. I have all the paperwork for you in front of me. I know that I turned in some, but I think this is the bench stuff that I was supposed to, anyways, I should have turned it in, but I was trying to get legal representation because he had completely took me out of my daughter's stuff during a temporary order, and I didn't know what to do.
I'm gonna review what has been filed. I know that there was a final parenting plan. I did not, and I have looked at that because it was in my presentation pile here today. I know that there was a motion that was filed by Ms. Winkles with the proposed new parenting plan, and there was also a notice of intent to relocate, and which wasn't, was that dealt with as well, Ms. Winkles?
No, Your Honor, my client's actually back in the area, so he's actually closer to Miss Ericson now, who was, I believe I'm not sure if she moved. We didn't get a notice for her move, and there's nothing been changed in the court. If she's still at the same location, then they're closer. They are closer because Mr. Anderson lived in Portland and now he lives in Tootle.
Okay. Okay. All right. I have one more matter to hear this morning, and I have a 9 o'clock docket. So I'm going to review everything that's been filed thus far, and I intend to either enter a final parenting plan or enter a written decision, essentially dictating what the next steps are going to be for these parties.
All right. Thank you.
And I'll review everything that's been filed at this point.
Do you want me to, I can run in these, all this that I didn't have the right cover letters for. Can I run that in this morning, please?
And I'd object just because it's not properly before the court, and we've waited for this for 9-10 months now.
You can file whatever you want to file, Miss Ericson, whether it's there for me to review when I need to review this.
Okay.
I can't dictate that because I don't know how long it'll take for you to get it filed and get it in the system.
I'm going now.
You absolutely have every right to file whatever you'd like to file. So by all means.
Thank you so much.
All right. Thank you, Your Honor.
Thank you.
Have any additional pleadings? Good afternoon.
Your Honor, I wasn't able to get in touch with my legal aid lawyer. She wasn't able to see me until this Thursday. So I'm hoping for a continuance.
Okay. Ms. Jeffers,
Your Honor, I understand that Ms. Kenota is not represented. We did set this over. I think it's been 4 weeks or so since the original information was filed. The court personally handed her the documents 3 weeks ago, and we set this over. I guess I'm not opposed to a continuance if there's some assurances that my client will at least get phone calls. We talked about this the last time we were here, and she has failed to do so.
I would like to talk to my legal aid lawyer first.
well, at this point in time, though, your court order that's in place, which is the parenting plan that provides for contact, is the order that's in place. And if you decide you don't want to follow that, that would put you in contempt of court.
Okay.
So if they want to do some phone calls, then you need to do that. I can certainly set it over, give you a chance to talk to an attorney. I think that's probably appropriate. It's a complicated case, but you need to follow the plan until that happens.
Okay.
So is that going to work for you?
So can you give me some time to talk to her?
I'll set it out a couple of weeks. You're going to see them Thursday?
Yeah, I'm meeting on Thursday.
Why don't we go 2 weeks to the 10th? That way that'll give an opportunity for them to reach out to your office, Ms. Jeffers, and maybe they can come to some agreements. Otherwise, we can hear it on the 10th.
Appreciate that. Thank you, Your Honor.
All right. And you didn't get follow the plan, at least as it relates to phone calls.
Okay, 10th at 1 o'clock again?
10th at 1 o'clock, correct.
Thank you.
Yep. And if you can, whoever is going to be handling it, make sure they get a hold of Ms. Jeffers and they can walk through, maybe you can come to some agreements.
Okay, thank you.
Okay. Kenota is present in the courtroom. We have Ms. Jeffers. This is weird. I'm not having any Zoom.
We can still hear and see you, Your Honor.
That's nice to know. I just can't, I don't have a Zoom screen, oddly. Give me just a second here. All right, so do we have Ms. Jeffers present?
Yes. Good afternoon, Your Honor.
Good afternoon. So I guess I'm trying to see what we're doing on this case today.
Your Honor, this is my motion for contempt that we've set over a couple of times for mother to consult with counsel.
Mm-hmm.
So at this time, Your Honor, we are asking that the court find mother in contempt. She does not deny any of the allegations. She basically responds by telling the court that she doesn't like the parenting plan, and for that reason, she shouldn't have to follow it. This is the third time we've been in court on this. It was made clear to mother that if she started following the parenting plan, we could work something out. The court reminded her to follow the parenting plan twice, and she still has refused to do so. For that reason, we are asking for a finding of contempt on all the allegations alleged. Civil penalty, attorney fees. Again, this is the third hearing I've had to appear on. Makeup time, and anything else the court thinks is appropriate. Thank you, Your Honor.
Your Honor, if I may.
Go ahead.
I responded to the, with a declaration, to the, contempt. I said on there that I acknowledged that he did try to call several times, but I also acknowledged that there were inaccurate times like 6:30 in the morning, or that there was times where he messaged that I felt threatened, so I didn't respond. As of recently, he has not tried to contact the children in over a year. I went back and I checked through all of my phone statements through T-Mobile all the way back until March of 2023. There has been 0 attempts on his end to contact via phone. Prior to that, the last time he tried to contact was in February for Eleanor's birthday. He called and he left a voicemail just saying happy birthday. And then in January, the month before that, he called and he said, happy birthday to Mary. I told both of them, neither one of them cared to respond with a return phone call. So we didn't. Mr. Thomas, when he has called at inaccurate times. He knows that there's always been a time zone difference, and he still calls, after bedtime, or like I said, 6:30 in the morning, which are not times that the children are available to speak. The last time that he's attempted contact with me was after our first court date. About 2 hours after that court date, he responded. He messaged me saying that he wanted to schedule time with the children, but at that time I did not acknowledge it because I wanted to speak to my attorney. Now, I have been working with legal aid, and as you know, I would imagine you knew that those lawyers, they're very helpful, but their time is limited when it comes to their volunteer efforts at times. So I was always put 3 or 4 weeks out before I could speak to her again. So this whole process of me trying to figure out what was going on took way longer than it was supposed to. I did not find out that he had changed the parenting plan until December 31st of last year, when I tried to enroll the children in school and they asked on the application if there was a parenting plan in place. And I said yes. And they said, okay, well, we need an updated copy of that. I was still unpacking because we had just moved back out here like the month before. And so I called my caseworker through child support and I said, hey, I need a copy of my parenting plan. Is it possible that you can email me one? And then she was like, yes, the one I have on file is from the 2022. And I was like, what? That's not accurate. It was in 2019. And she was like, well, this is the one I have. So she emailed it to me. I provided that proof and Exhibit A in my paperwork that I was submitted. That was the email that she sent to me. Mark has a history of violent and aggressive behaviors, which is why I not always responded to him and his attempts to get in touch with the children. He has a history of that. And I also provided that in the exhibits in my declaration, where he's arrested. He says he's not in and out of jail, but his criminal history clearly shows that he's in and out for domestic reasons. This is not something I'm making up. This is, Ms. Jeffers tried to argue that my interactions with him were over 10 years ago, but those all still apply, because if you were to look at his criminal history, it's still happening. Like every 2 years he's in jail.
Well, I guess my question, and this is for Ms. Jeffers, we were in court on the 27th, and I believe that was when I indicated that the order needed to be followed. Has there been any attempts to make any contact since then?
No, sir. And he's
But,
been.
ma'am, I'm just talking to Ms. Jeffers.
Sorry.
One at a time, please.
Your Honor, my client, as mother acknowledged, has contacted her and asked to schedule to talk to the children or FaceTime them at times that are convenient for her. And as she also indicated, she has refused to respond.
Can you answer my question that I just asked? Since August 27th, has there been any attempts?
I can't say the date. I'm going to pull my file, Your Honor. I thought I filed a copy of that message with my motion.
It was on July 7th.
Talking August 27th. Just like,
I can't confirm that, Your Honor.
okay.
I don't know that my client has any contact information for her, which is why we had to serve through publication and things like that. All he's got is Facebook, and she hasn't responded. She's got the message clearly.
Your Honor.
Okay. Well, here's the thing. I have indication, you just told me that you became aware of the parenting plan in December or early of this year, correct?
August of last year.
August of
End
last
of
year.
August of last
Okay,
year.
so you've been aware there's been another plan that was done.
Mm-hmm.
I understand you don't disagree, you disagree with it and everything like that. And that's a separate issue. When we were here on the 27th, what I specifically said is you need to follow the plan. What I don't have is What I have is proof of service on all of these documents by putting in the mailbox July 30th. Just, I mean, that's when it was mailed to you, this motion. Mailed July 30th.
And I think I've got an order to shorten time. In any event, we set it over, Your Honor, to give her a chance to respond. So we've got service there. Yes, the motion to serve by mail and the motion in order to shorten time were filed on July 30th. We came here on August 6th and set that over to August 27th at her request. And then we're here again today.
Your Honor, that I hadn't received the motion for contempt when we showed up for that court date. So you actually gave me a copy of it when I left. And then when I went to check my PO box later that day, it was indeed in my PO box. So court was set over because I hadn't gotten it yet. And then when it was sent over, then that's when I asked if I could have a continuance to speak to my lawyer because I couldn't get in until 2 days after our last court date.
That, I mean, I'm just looking at the notes and that's essentially what process-wise, that's kind of how we got here.
Yeah.
And I guess, well, here's my question. When we were here on the 27th of August, which was the last court hearing we were at, I indicated you needed to follow the plan. My recollection was you said you would, but I don't know, are you not willing to follow that plan at this point?
I am willing to follow it, Your Honor. I unblocked him. I've had the same cell phone number for over 15 years. That has not changed. He has my email address. That has not changed. That's been the same for over 15 years. And my Facebook messages, and I show proof that all of the contact that he's attempted through all 3 of those avenues were in my declaration. And the last time he tried to contact was on the 27th, which was our first court date. About 2 hours after leaving court, he messaged me via Facebook saying that he wanted to schedule times with his kids, but that was the last time he's attempted. I have him unblocked. He is available to call, and I actually have a schedule of availability for the girls based around their school and their sports that I can provide to the court as well. But as far as being held in contempt, I'm trying to hold up my end, whether I like it or not. My phone is open and available to him, and he has not tried, not once.
All right. So what I'm inclined to do on this is simply set this out, get that schedule, and then I want to see if she's going to follow through the plan.
I'd love to do that, Your Honor. And if she wants to provide me with a phone number, she's got my contact information. As she said, she unblocked him. So I don't know if that my client knew he was unblocked. I don't have an email address for her. Otherwise, I wouldn't have had to serve through publication last time. And she's keeping her address confidential. So if she gives me a way to contact her, be happy to schedule around her and the children's schedule.
My PO box or my email address has been on all of the papers that I've filed with the court. It's City Slick. Like I said, it's the same as it's been since she emailed me a couple of years ago.
And received no response, ma'am.
I know, because my inbox was flooded by Mark's junk mail, so I stopped checking it.
So she does have her phone number listed in the last pleading. So it appears to be. So what I'm going to have you do, I'm going to have you provide them with your schedule. I'm going to set this out about a month. Let me see. Let's go to the 15th. I know I'm gone for a bit of the first part of October. So I'm going to review it on the 15th and we'll make a determination if you're following the plan.
October 15th at 1 p.m.
Correct. And you need to provide that information to them, and that can be done via email. That needs to be done by the end of business today.
Do I need to provide this to the court as well?
I don't need a copy of it as long as you get it to the attorney's office.
Okay.
Okay.
Ms. Jeffers, can I have your email address?
Yes, it is. It's kind of long. I will go ahead and send you an email right after this hearing so that you will have it available to you.
Thank you.
Thank you, Your Honor.
You're welcome. So I know we had set this over. And how have things gone since September 10th?
I will indicate that my client is receiving some phone calls. He's not getting what's allotted to him in the parenting plan, but he is getting some phone calls.
Your Honor, he's gotten every phone call that he's asked for except for one. The girls do not ever request to make phone calls to him, so there's nothing I can do as far as that goes, and he's basically called once a week since he got their information.
Okay. All right. So this is a very, very unusual case because of how we got to this point. My thought on this would be to set another review on this. It sounds like that things are following along where they're supposed to be at this point. I think there was clearly some challenges early on in the case, but I think there was also a lack of understanding of what the law was or what the court order was, because that was done from what the court record indicates. It was done somewhat. I mean, it was done appropriately, but there's no guarantee that Ms. Kenota had that order until this proceeding got started.
I'm fine with a review, Your Honor. I mean, what my client really desires above most is to just have the contact with his children for the parenting plan.
Right, and I understand that, and he should have that according to the parenting plan. So what I'd like to do is keep an eye on this and maybe review it out about a month or so. Make sure that everything is following through. We don't have any issues, and at that point, I would likely deny the contempt at that point. But I think I want to make sure everything's following through. I understand there's some disagreement with what the order might say, but that's where we're at.
Appreciate that, Your Honor. Can we go to November 19th?
We can do that. November 19th at 1 o'clock.
That works.
As long as everything is going well, counsel, if you decide that there's no need to proceed farther, you can strike that. I'll leave it up to you.
Appreciate that. Thank you, Your Honor.
Okay. All right. That's all today, and welcome.
I am here, Your Honor.
Ah, there you are. Sneaking in court on me here. So did you get a copy of the proposed order on this one?
Your Honor, I had one thing I wanted to bring to the court's attention in our proposed order. I believe it matches what the court ordered except for J. The court did not make any decision about who would be responsible for paying for reunification counseling. I wrote in the order that Mr. Diaz would be responsible, but the court really didn't make any rulings about that. My thought process was that Mr. Diaz has never paid child support, does not have a current child support order, and at our last hearing, Mr. Diaz offered to pay for the cost of Miss Hawkins and the children to fly up to Cowlitz County and the cost of a hotel for them to stay here while they started reunification. So based on that offer and the fact he's never paid child support, I'd ask that he be responsible for the cost of reunification counseling.
And I would ask the court to reserve on that issue. We're still in the process of figuring out exactly who it's going to be through. We have two individuals who have been come to our attention who are licensed in both Washington and Texas that might be able to take on the counseling, but we've not set up appointments with them yet. We're trying. I don't know the full cost. I think that absent more information about the costs, what insurances are going to cover and whatnot, I think it's more appropriate to reserve on that issue.
Mr. Lawrence, I see you're here. Do you have any comments on any of that?
No, Your Honor. I know that the council have reached out to Brenda Bible, who is licensed in both Washington and Texas, as well as another agency. To my knowledge, there hasn't been any response. I reached out to Ms. Bible myself and have not received a response from her. So we're, as Ms. Ernest has indicated, we're kind of in a holding pattern right now.
And I guess I'll update the GAL. I was able to reach Ms. Bible, and we're in the process of, I sent an email saying if there was some availability, we might be able to all reach for the coming weeks.
Okay. Do you have any issues with the rest of the order?
No,
Okay.
no, it's just Jay.
Well, I think I'll do on that, since I didn't order that specifically. I'm going to reserve on that. Let's see what kind of costs we have, and ponder how I think that should be apportioned.
Okay.
Cochin? Oh, well, if you're not in a match, there might be some crucial stuff that you can only answer. But he's not letting.
And Your Honor, I know our next hearing, I believe, is scheduled for December. I'm wondering if we might be able to schedule another review hearing, given that we still are not sure who it's going to be. We may be able to get an appointment with one of the counselors in the next coming weeks, but I want to make sure there's we're still on track.
I think probably given the circumstances of this case, having a review and maybe a month out probably makes sense. And you can, if there's no need for it, you can always strike it. How about if we go, let's see, I think I'm go the 24th of September at 1 o'clock. That's just a review hearing. If the council agree and there's no need for a review at that time, then that just let the clerk know and that can be stricken.
All right, thank you.
And that also may be a time we can address the cost if that's hasn't been resolved.
Okay.
Okay.
That makes sense.
Your Honor, did you say September 24th?
I did. Does that work for you?
That's fine, yes.
All right, September 24th at 1 o'clock.
Thank you, Your Honor.
Thank you.
And I am signing the order with the change to just reserved on Jeff.
Thank you.
And you're authorizing that 24th to be stricken via email.
Yep, you can strike it via email as long as everybody's in agreement.
Perfect, thank you.
If you don't need it. And we will leave the December hearing in place. Okay.
That matter's ready. So in this matter, I'll let the court know I did communicate with Mr. Sosowski. He was not served. My client was not served. And my office was only served yesterday and only with an order to go to court and nothing else. So in this matter, there's just simply not service. So we're not properly before the court. Given that lack of service, Mr. Sosowski appropriately decided that he would not appear today. And I thought that was reasonable. So we're just asking the court to strike. There's not service for today.
Right. And
I'm here.
there you are. Okay. Very good.
Yeah.
So that would not be appropriate service for today, and it would need to serve everybody.
We have been trying to serve Mr. Ramos, but I don't have his address. So we've just been trying other ways of service. So it's just something that she was the only one that we could serve right now. Mr. Sosowski, I wasn't sure that I needed to serve him because last I knew he had withdrawn from the case.
I believe that was from the other case, but so he would need to be involved in this one. For purpose, if there's an issue, this is a recollection when I looked, this was essentially a request to follow. Let me see here just a second.
Had to do with summer vacation time.
Right, it was a contempt hearing. I think for the purposes of this issue, I will allow service to the attorney's office. That would be for both attorneys, but it still needs to be appropriate service, which is not good for today.
Okay, I can have the other attorney's office served as well.
Yeah, you need to serve both of them. And if you look at local court rule 88, that gives you the timelines for that.
Okay.
So you need to comply with that. And at this juncture, given what's at issue, and along those lines, Ms. Baldwin, I think given the variety of the level of conflict in this case, I think probably minimizing the contact between the parties is probably appropriate.
So long as I can provide personal service to her in a similarly easy way, such as via email to her.
I think that's appropriate.
I'm totally okay with email service.
Yeah, I think that's appropriate given the circumstances. Are you still local, ma'am?
No, I'm not. That's why I'm okay with email service.
Yeah, that makes total sense. So as long as you make sure that Ms. Baldwin has your email, that can be served in that fashion. I don't know about Mr. Sosowski, so you'll need to check with him if he's agreeable to that. I'm not going to order that he be required to accept email service.
I can have someone, sorry, I can have someone serve his office.
Yeah, he may be willing, but you need to reach out to him and check that.
Okay.
All right. So I'll strike it today.
All right. Thank you.
Thank you.
All right. So I think we are probably, Ms. Baldwin, Commissioner Carmi is going to handle the Beosian matter since she entered that order. I wasn't at that hearing, and it seemed to me, given the kind of complex nature of the order, and I know she's doing a presentation right now. She'll be logging in to handle that and one other matter. So
no problem. Thank you.
So she's handling those two, and I have not seen her yet.
I'm here for Mr. Everdale.
All right, very good. Looks like I have both of them also on, I think. Okay, so I did have a chance to review through the paperwork on this one.
Your Honor, before we go further, I was a little concerned that Ms. Winkles indicated that the child Adrian is on this Zoom call. Adrian is 17 years old, and the court appointed the court investigator so that Adrian's voice could be heard. I recognize that he's 17, but I still don't think it's appropriate for him to be present to hear all of the financial issues between his parents. I don't think it could do him any good to be at this hearing today.
And Your Honor, again, my office had nothing to do with this. We just heard through the grapevine that the child was going to do essentially log in. I guess it's the public is able to do that in some fashion.
No, the public can attend in person. It's not a public hearing from Zoom. So, and I don't see. I don't
know if he is here. I heard that through the grapevine, so I wanted to make sure that Your Honor knew what I knew.
Yeah, at this point, I would not want him to sit through the whole hearing, given the issues that are before us. So.
Earlier in the docket, Mr. Everdale became unmuted and seemed to be talking to someone about their ability to be present during the hearing. So I had the impression that Adrian may possibly be present with Mr. Everdale.
I don't think he's present with Mr. Everdale, but my staff did ask him to call his son and see if he was on the record. And that we were talking about it. I believe that's probably what you overheard, is that my staff calling him.
Yeah, I don't see anybody logged in, so.
Okay. And if Mr. Everdale, if the son is there, we'd ask the son to leave the room. I'm not sure. I believe he was on the phone, but I think that's appropriate.
I would agree with that. All right, so everybody received Ms. Schaefer's report, correct?
Yes.
Yes, Your Honor.
Okay. So, and I didn't have any real specific questions about that. And there was a declaration that Mr. Everdale filed. We received it yesterday. I don't know, Ms. Powers, did you get a copy of that?
I did not get a declaration yesterday.
We filed it last week on Friday, and maybe it got scanned in later. You should have received that. It was a declaration of Michael Everdale in response to the investigator summary.
This was signed August 26th.
I did not see a copy of it.
We are training new staff members, and that might be, we're having some technical difficulties training law clerks. My apologies. It should have gone out on Friday. My client wanted to respond to the investigator summary. I believe we only received that last week. And so he had just some responses to some of the information in there. That's what we were attempting to file. And then also a brief response to Mrs. She submitted some financial information, and we also submitted some financial information. I didn't know if we wanted to set this over 1 week then so that everybody could have all of the same information.
Well, I'm concerned about proceeding because I assumed that Ms. Powers had received this.
Me too, and if that's my stuff's if we drop the ball on that, my apologies to everybody.
Can I just inquire, in the response to the court investigator's report, is it Mr. Everdale's position to still follow the recommendations of the family court investigator, or is he asking for something different?
It's different.
Okay, then we probably need it. We probably should set it over then.
Yeah. So why don't we do this? I don't think there's, there's some urgency on this one, but it's not to the point that if we set it over 1 week, that should give an opportunity for Ms. Powers to get the documents, review through those, see if there's any concerns. Are you both available on the 3rd?
I am.
I will make myself available. Yeah.
Okay, so the 3rd at 1 o'clock, and we'll come back and hear that. And if just for the parties' reference, we would prefer, given the nature of the financial things that would be being discussed, it'd probably be more appropriate to not have the child there. And I understand he's 17 and he has some interest in the case, but that probably doesn't need to be there. So.
And we will make sure we get Ms. Powers served. And I just wanted to ask if the investigator was served, because we also tried to serve the investigator. Okay, my apologies. I will handle that immediately.
Okay, Ms. Schaefer, are you available next week?
Yes, Your Honor.
Okay, so we'll set this over 1 o'clock on the 3rd of September.
All right. Thank you, Your Honor. My apologies again.
Got it, okay. And, all right. So this was set over from last week. And so how do we, I assume there's been no agreement since we're still in my docket, so.
That's correct, Your Honor. This matter's been set over a few times. At this point, we have a few issues before the court to decide. The first one is a parenting plan for Adrian. And I want to remind the court that Adrian will be 18 at the end of October. He's the only minor child left. The court had appointed Ms. Schaefer to talk to Adrian and find out what his desires were. The court investigator's report indicates that Adrian wants to continue living with his brother through the coming school year. My client is in agreement with that and believes that Adrian should have the ability to decide where he's residing this year. So we would ask that the court make both parents joint custodians, allow the child to continue living with his brother, give both parents joint decision-making, and let the child decide what kind of contact he wants with both parents. Adrian is mature for his age. He has his own car, he has a job, he's doing Running Start, he's a responsible young man, and we believe that it's appropriate for him to make that decision. The next issue is whether or not the court wants to order child support. We had initially proposed in our motion that neither parent pay child support and that each parent pay their proportional share of Adrian's Running Start costs. I believe that the court investigator's report recommended that both parents pay child support. We did file updated worksheets with the court on August 20th. We have the mother's income. She grosses $55,711 a year. That's paid out over 10.5 months of the year. We filed an updated financial declaration on August 20th, and we also filed a letter from from the mother's employer showing her actual income, and the employer explains that she's paid over 10.5 months. We also filed additional pay stubs that show time periods where the client was not paid at her regular level because she has to take a certain amount of unpaid leave every year so that she's only paid the 10.5 months. Based on our worksheets, if the court orders child support, the transfer payment from the father would be $791. The transfer payment from the mother would be $542. I think both parties agreed to pay their proportional share of the child's Running Start costs. Since the child is living with a non-parent, I'm just not sure how that impacts the court's ability to award child support. The other issues before the court is the family home. The court has previously ruled that Mr. Everdale will pay the mortgage and utilities until the house is sold. We would ask the court to order that this house be listed for sale as soon as possible. We're also asking that the court allocate the debts. There are 3 debts beyond the mortgage between these parties. There is a car loan on Mr. Everdale's car that owes about $26,000. We ask that Mr. Everdale be responsible for this loan as it's for the car that he's driving. There's also a personal loan where the parties owe about $38,000 and an American Express where they owe about $17,000. We propose that each party pay off half of the personal loan and half of the American Express card. Lastly, I just want to point out to the court that reviewing the income information from the parties, the father nets $5,151 a month. Ms. Everdale nets about $3,529.34. When you subtract the mortgage from father's income and rent from the mother's income, that leaves dad with disposable income of about $2,775 a month and mom with only $1,629 a month. So we believe that our recommendation for the allocation of debts is appropriate. We're asking the court to order the home be sold immediately, and we'd ask that Adrian be allowed to continue residing with his brother. Thank you, Your Honor.
Can I inquire how you came up with your net for him after housing?
Oh, the housing is the mortgage. So the mortgage payment each month is $2,376, and father receives VA disability of the $5,151.
I thought that's a different number than I had for the mortgage for some reason.
And I can clarify the number on the mortgage.
Okay. Go ahead.
Yes, Your Honor. So I'll start kind of going backwards to forwards. If we look at the debts of the parties, we have a few things. Number one, my client does get VA. However, he gets a bump up because he's married. The moment he's not in line with what her income is. Additionally, her income is not actually correct. If you read the letter that was actually written by her employer, it says that the course of the year she makes over 60,000, and then but she only works 10.5 months out of the year. So what they're doing is essentially saying that she makes 10.5, 10.5 months of the 12, which actually puts her income at more than what Ms. Powers is stating. It actually puts her income closer to 4,876 gross, which then gives her a net of it then gives her a net of 3,915. My client currently has 5,319. The moment he's divorced, that goes to 4,815. So you have these parties at very, very close numbers. And then if we start looking at the bills, my client has been shouldering almost all of the bills. And he gives that to you in the declaration that he submitted earlier in this case. So he shows that he pays $3,000 for insurance because they have other children as well. And they're adults, but they're like 19-year-old adults, 20-year-old adults. And so if you look at what my client's actually paying, he's paying around $314 a month for the insurance. He also pays for all of their cell phone bills. It's $238. And we go on from there. He gets essentially the car loan that he's paying for. And this is the thing. They want him to pay for his own loan because he has the car, but this is a community asset that goes on his side of the spreadsheet. And the debt goes on both of their sides of that. We look at the assets and debts, it goes into the community. So why my client would be asked to pay for this, granted he has the benefit, but Mrs. has a car as well. Hers just happens to be paid off in full. So we put the value in and we don't get to then make him pay for it because that's essentially giving her a much bumped up value of 13,000 that would normally come off of her side. So if they're going to pay one half of the Amex, one half of the personal, my client has no problem with that. They also need to pay one half of the car loan because it is a community asset and likewise it's a community debt. The mortgage, my client's been paying that as well. That's $2,376.26. You can see that at Exhibit D. It's from Freedom Mortgage. It also includes the payment history over the last 90 days. That's on there, Exhibit D, the Amex card, the ADT payment history, the Wi-Fi. So Mrs. just sees the house as existing on its own without any of the expenses that go with home ownership. That's not accurate. We also have the bill from the city of Longview and so forth. But even taking into account all of those bills, my client could actually pay those until the end of the year. Would he have any disposable income at all? No, he wouldn't. But the fact is that he could allow the child to have a stable place to live. And the court did not order that the house was to be sold. In fact, the court stated that you wanted more information on what everybody made. You wanted more information on everything, which is why we came back here. There was no order that the house was to be sold. There was no order that the bills were to go a certain way. In fact, Your Honor, like I said, wanted more information, which is what we provided. Really, this is an asset of the community. There's no reason to sell it at this point in time. While I'm sure Mrs. would love to have some money, she already has 84,000, as you'll see from my client's declaration, from selling that property. This house can be kept in good condition, wait for the child to graduate from high school. The child's going to be 18 in 2 months, and allow him to have some stability of where he lives. My client will pay. There's not going to be a wasted asset. That's usually when we sell them during litigation. But there's no risk of this house going under. Client's been paying it thus far, and he shows you proof of that, Your Honor. If we move on to the child, the investigator did state that the child would rather live with the brother. But if you read into that, you'll see because he says he doesn't want to move in with dad only to sell the house. And that's the thing. The child needs stability, asks for stability, says things have been an upheaval. Giving him the stability of finishing high school and running start in the house that he grew up in would be the most stable. And my client agrees with Ms. Powers. The child should be able to decide where the child wants to live. My client has no problem with that whatsoever. However, the court unfortunately doesn't have the authority to order that the child can live with the brother because the brother, this isn't a minor guardianship. The brother isn't a party here. The brother, there's no unfit ruling. There's no consent by both parties with the brother necessarily. So it would be problematic. So my client agrees with joint decision-making between mom and father, but that child gets to decide which one of those parents he lives with. And obviously the parents between themselves can allow the child to live with the brother, but I don't know how the court would go about ordering that. The same goes with child support. While both parents should pay the child's expenses, and my client shown that he has, the fact is I don't believe the court would have the ability to redirect child support to a non-party in the case. I did look at some case law and I couldn't find any sort of ability to do that. And I might be wrong. I only looked for about half an hour, but I couldn't find any. I think in this case, probably no transfer payment would be appropriate, and that both parties pay for Running Start, both parties pay for their son, and both parties kind of assist in his graduation. He will be 18, but he'll still be in Running Start for this entire year. My client thinks the parties could probably work this out. However, that's what he's requesting. He's done his best to get the court all of the income, but when you really look at how much he's paid and how much she's paid in her income, and that would be on page 3 of my client's original declaration, he makes you a chart showing the total monthly payments, the children's share of those payments, the husband's responsibility, and what the wife's responsibility should be. And he gives that based on their proportional share of income and how much they make. And even with his his dividing them up, he still has 3,159 of the total bills and her at 2,258. So my client would ask that spreadsheet on page 3 of my client's declaration, which was filed in this case, I believe, I don't have a CP number on it, that be entered by the court. That is incredibly fair, and it literally goes to the proportional share of income and allocates it almost exactly. And so that's what my client's asking today, to be able to stay in the house, to not have it sold yet. That's something that can come at trial, that they pay the amounts shown on page 3. The child can decide where he lives. No transfer payment of child support between the parties, but they agree to continue paying. And that my client's car be one of those things that's paid for half and half, considering it is a debt of the community, and likewise it's an asset of the community. And Mrs. has a car that's fully paid off, and there needs to be some equality here given the length of this marriage. Thanks.
Let me ask you some questions about, I'm looking at, it's the declaration filed August 14th, I think is what you're talking about, with a payment breakdown. So the very first line, I'm not sure I understand either the first 2 entries, the car insurance or the phone bill. Says the total bill is 314, but 209 of that's the kids, and that still leaves the rest. So I'm not understanding what.
So yes, so the car insurance, the 314 is for the entire family, and the children's share is just that 209.50. And then so she was on the insurance before, but I believe she's actually taken herself off insurance now. But the 314, the additional 114 was my client and Mrs. And that was their share, that additional kind of part of that. And then the phone bill is the same. So the overall phone bill is $238.42 for the whole family. And then the children's share, just the child's share of that original or that total phone bill is $185.49. The additional $40, I believe it is $20 per line, was Mr. and Mrs. And so that's how that is allocated, why it's a little bit broken up, because normally, and we didn't know if Mrs. got her own phone, got her own insurance. So we wanted to allow your honor to see what the child's share was versus what the adult share was, just in case you wanted to go deviate downward with that, so that she wasn't paying a proportion of my client's phone or the car insurance for my client.
Okay, I completely do not understand what you just explained to me, because the total bill is $314.
Yeah.
What's
they have more than one
got
child
to do with anything?
Well, the whole bill is $314 per month. But if we're just looking at responsibilities of taking care of this kid, it's $209.50. Because obviously he's 18 years old and driving. So his insurance is quite a bit higher than their insurance. They're on the same bill, but if you look at the actual bill, you'll see that he's out of that bill. Like he has his own, you can itemize what's his, because his bill is so much more expensive. So 209 is for their son. That's how much it costs to insure him per month. And likewise, his phone bill is $185.49 per month. And I'm not sure if that's because he has a new gadget that he pays monthly or what, but those bills are all attached as well.
Okay. Again, I'm not sure I'm following the math, but is your proposal that they each send a check for half of each of these bills or whatever the number you've got down here?
No, they have a joint account still, and they're still putting money in that joint account. And so the hope would be that they just continue using it until everything is separated. And so my client still puts money in it today. I actually believe both his Social Security and VA disability both go into the joint account. And I believe Mrs. was also putting money in there at some point. So that the hope is that they just both put money into the joint account.
Well, and who's going to pay the bill?
It comes out automatically. All of their bills are auto deposit or auto withdrawal, whatever that is, automatic payment. And again, it shows that on the bill.
Your Honor, I would object at this point. This is the first time hearing about this idea that both parties are going to put money into a joint account and just have the bills come out automatically. It's my understanding that my client is not using the joint account and hasn't for quite some time. And she now has her own apartment with her own set of utilities and expenses, her own insurance, her own phone plan. It does not make sense to me to put this all into a joint account and continue to have these bills combined when the parties have already started separating them. I do have a brief reply. I don't know if the court would like to hear from Ms. Schaefer first or.
Well, I read Ms. Schaefer's report, so I know what her recommendation is. I don't know that unless you've got something additional you wanted to add, Ms. Schaefer.
No, Your Honor, I'm good. Thank you.
Okay, but I did review the report, so I'm aware of what that recommendation is. So go ahead, Ms. Powers.
Thank you. Just briefly in reply, we have the father's income at $5,151. Ms. Winkles has indicated once the divorce is done, his income will drop to $4,819. That's only about a $200 to $300 drop in income. That's not a significant drop. The father still has significantly more income than the mother. Ms. Winkles' interpretation of the mother's income is incorrect. When you review the letter from her employer, which we filed with the court, it makes it clear that they have the amount that she would earn if she worked 12 months of the year. And then they clarify that her contract is only to work 10.5 months of the year. We have also submitted her wage stubs that show there's a month and a half worth of time she has to take off during the year that's unpaid. And we submitted the pay stubs that show that that has happened this last year. And that matches in alignment with the letter from the employer. So we do know what the mother's income is. In terms of the father paying car insurance and cell phone bills, it's his own choice if he wants to pay for the adult children. I don't think that that should be factored in here. The mother is not living in the home. She has moved out. Mr. Everdale is currently living in the home. Miss Everdale has her own expenses for rent and for utilities and her own bills. If in terms of who has to make the house payment, the court already ruled on July 30th that Mr. Everdale will make the house payment and can continue to live in the home until the home sells. So that it's not appropriate to relitigate the issue of who's paying the mortgage since that's been decided. Lastly, in terms of Adrian, I want to remind the court, we're less than 2 months out from him turning 18. So at that point, Adrian can live wherever he wants, regardless of what the court orders. The whole point of having the court investigator was to get a neutral opinion from Adrian about what he wants without the influence from either parent. And he's let the court investigator know that he wants to be with his brother. And that's what we think needs to happen. Although my client does have room in her apartment if he wanted to reside with her.
Okay. So I guess I'm not clear what your client's income is. I've got two different declarations from her, one that listed at $42.92, one that listed at $35.29. And the letter from the school was not really helpful in determining which of those is accurate.
I can tell you that there was a difference because when the employer submitted the letter, they gave us the updated income for the 24-25 school year, and that ended up being a little higher than where we had originally had her income. So that's why it was higher the second time around. But it does show she earns $55,711 over the course of a year, and that's paid out over 10.5 months. So I took the $55,711 and divided it by 12 months and got the gross of 4642.58, and then the net of 3529.34. And we did file an updated financial declaration with that information, worksheets, and sealed financial source on August 20th.
And
that's the most accurate.
Well, that's what I'm confused about, because that one's lower, not more.
And Your Honor, just so that
Just a minute, Ms. Winkles. I'm trying to understand. I'm looking. You filed the declaration in June, and then you filed one in August. The August one is less by about $700, and I don't know what your client makes. And then again, for Ms. Winkles, your client's making $51.51. Now you're telling me that he's not going to be making that once this is final, but he's going to make that during the course of this, I assume.
That's correct. Yeah.
Okay, so the 4819 is not relevant for our discussion today, correct?
Okay, absolutely.
Okay, so it's 51. It's 51.
Just briefly, Your Honor, this if you look at that letter they filed at CP 47, it says 63,670 is the annualized amount for the 12-month period. She essentially only takes home 10.5 of that. So you would divide the 63,670 divided by 12 is 5,305. That is what she would make per month if she were on that contract, but she only works 10.5 months of the year. And so that total gets you back to the 55,711. So what we have to assume here is that she's actually making 5,300 per month, and then for a month and a half she's not working. But it also says that she only has 30 days of scheduled leave without pay per year, which means that 2 weeks of that 10.5 months she gets scheduled leave, which is paid. So now you're looking at somebody who has a salary of 11 months, which means that if you take the numbers that are there, 63,670 divided by 12 equals $5,305.80 times 11. Her annual salary with what she works is $58,364. And then if we really want to get a monthly from that, it becomes $4,563. So I think that is the actual salary. And additionally, if you look at her lease contract for her home, which we've submitted, she even states that her salary is the higher of the amounts, the 61,816. She states that in her lease contract, which we supplied on my client's first declaration. So she's not this low amount. She's clearly making a lot more than she says she is.
Your Honor, I've refreshed myself on how I did my calculations. I literally took the letter from the employer that lets us know for the 24-25 school year, she's earning $55,711. That's paid over 10.5 months. Because that's what she's earning, the $55,711, I divided that by 12, and that's how I got the gross of $4,642.58. If you review the pay stubs that we submitted with it, it shows that she has pay periods where she earns 0 because she's required to take 30 days of leave without pay throughout the year. That's how we get to the 10.5. She would earn the 60 required to take.
I have no idea how you got that out from that letter. And I'm reading the letter, and the letter makes no sense in and of itself. So it doesn't tell me what she makes every month.
Well,
I don't come to the same kind. I mean, I read that, it doesn't make sense what you're telling me. And the two declarations don't match up with those numbers, as far as I can tell. So
I think the other place to look is if you're looking at her wage stubs, she has a salaried amount for a pay rate. She's paid that amount twice a month. That's the twice a month that she only gets 10.5 months of the year. So we've got the letter, and then if we go to the next page, we're still working under the 23-24 contract, which based on my reading of this letter, puts her at $54,088. Divide that by 10.5 months, divide that by 2 paychecks per year, and you essentially got the same number as the $2,652.92 per paycheck. Again, that's just for the 10.5 months. And you can see on this August 9th paycheck that although the pay rate is listed at $2,652.92, the actual amount paid this time period is $0.
So do we have so the pay stub in the July pay stub? I'm not sure if that shows earnings of maybe $2,652 and change.
$191.48 net. And again, it's because of those required days off that she has to take.
And that's the thing, is it says $2,652 semi-monthly, which means she's earning exactly what I've stated, which is $4,863 a month.
Except that when
It's actually more than that.
What was actually paid out, that's not what was paid out. It's very strange how they do this. But my client has explained, and when you look at the pay stubs combined with the letter, combined with my client's explanation, those fit. Any other explanation doesn't fit based on the nets that have actually been paid out.
Does your client have a W-2 from last year? I assume that would answer my question, probably.
Yes, and let me double check. I think that we filed it, but let me double check.
The one thing I'll state is I don't believe she had the job the entirety of the year, and that was one of the problems.
She's been with this employer for many years.
I believed her position had changed.
Yeah, I don't recall seeing a financial or a copy of a W-2, but I could be wrong on that.
We filed the party's income tax return on June 26th. My client is the only income listed there. And it shows her W-2 wages were this is the 2022 income tax, it looks like. Her wages were $44,035. Let me see if.
And that's what I was saying. I don't believe she worked the entirety of the year. I think I had that information.
And then we also have the 2023 here, and she grossed $48,128.
And I'm going to state, I believe that she actually worked at a different position, and because that was on her job hiring, which is one of the documents we submitted, it showed that she changed positions and she went to a position which was better paid, which is why you'll see in 2023 and 2024 at the beginning, 2023 and 2022, her income was so much less.
In her financial declaration, she lets the court know she's been employed at this job since August of 2015.
If you look at page 10 of that CP27, it actually gives her full income for that year is $61,905. And that is the credits pulling that from the actual 1040, where his is not included as income. Obviously, it's disability. And that is the 2022, again, page 10 of that CP27.
The clients let me know that she has held the same position for the last 3.5 years.
Okay. Well, that 61,000 should be the right one then.
That's the child care credit calculation.
Well, the income, well, I guess actually the Social Security benefits are taxed. So if you look, I guess at 44,000 was 2022, and then there was the taxable amount of Social Security benefits. That's just from the page 1. But again, I would probably object to stating that she's had the same job, because I would argue that she hasn't, especially given what they say she earns per year. Again, this is another number that doesn't mesh up. 44 versus 51 versus 55 versus 63. None of these numbers are even close to one another.
And I would point out that the numbers are not going to match.
Well, counsel, we're going back and forth on information that I don't apparently have, because that's not the information that's in front of me. At this juncture, I think what I'll do is simply take this under advisement, and I'm going to go back and I'll I'll plow back through, see if I can come to a determination of a number that I can live with, and then give you a decision on all the issues.
Thank you.
Okay, thank you, Your Honor. Is that, you'll give us a decision on the allocation of payments and stuff as well?
Yes.
Okay, sounds good. Thank you, Your Honor. Do we need to set presentation, or you want to just email it to us?
I'll just email that out.
Sounds good to me.
Thank
Thank
you.
you, Your Honor.
I think I saw both attorneys, and I think I saw Miss Weston. And Mr. Weston is present in court. Please have a seat at the table there, sir, by a microphone. All right, so this is on for temporary orders. I did have a chance to review through the pleadings on this case. So counsel would like to address.
This is technically my client's motion. Behind the scenes, Ms. Bynum contacted me today in regards to her client's parenting plan. And we have received that now. I know that the court hasn't. I know that I don't know if Ms. Bynum wanted to address that issue first.
I actually do, because it's come to my attention since you and I spoke this morning, Ms. McLean, that the court also doesn't have my client's financial deck, and I cannot even get confirmation that the child support documents have made it. There was a breakdown between a new paralegal and the messenger service. And while I've been sitting here waiting for the opportunity to address the court, our online filing system is updating. So if the court was to question me about the documents it has received, I can't even access the file at the moment. So my apologies to the court. These are technological failures on our side of this 100%, but we need to set this matter out for at least a week. I cannot proceed today. It's too prejudicial against my clients, especially with some of the requests that are being made by opposing party.
So I guess my only response is I understand that there's been some changes in Ms. Bynum's office. We did already by agreement set this matter over 3 weeks. This was supposed to be heard initially 3 weeks ago. So we're now a month and a half out from when Mr. Weston was served in this action. And as you saw from my client's reply declaration, the finances from him to my client have been extremely limited, and she needs some financial assistance. So technically, we think that we're properly before this court. We've already provided some allowances of that first 3 weeks set over. My client would like to proceed forward because she does need financial assistance. If the court is inclined to set this over, then we would ask that the court consider at least adopting my client's request and order that Mr. Weston is to pay my client at least what she's requested at this juncture. And we can figure out how those things float. She's been having to borrow money from her folks because the monies that when they split the accounts, it's my understanding that those have now been depleted, trying to supplement her living expenses since there's been limited monies coming from Mr. Weston. So.
Well, and if you'd had the financial declarations, you could see that what is being requested in terms of financial support is not necessarily something that he's even in a position to provide. Again, why it's so important that we make sure that all of the documents are in the file. And again, I can't even answer questions about the documents that we have filed because I can't access the online filing system. We're not asking for a long setup, we're just asking for 1 week. But again, given what is being requested and the information in the documents not before the court, it's too prejudicial to my client to proceed without, in essence, flying completely blind. And it's our fault. It was a technological issue, and I apologize, but I cannot make the documents appear before me.
Yeah, technology seems to be our theme today, so I do understand that. Why don't we do this? It seemed to me when I read through what I have here, there's going to be some amount of money transferred, no matter what we do. So here's what my thought is. I'm going to have Mr. West, I'm going to have you pay $1,000 to her. I'll determine when we come back to court how that's going to be applied. Simply between, so I need to have you do that. Can you do that today?
I'm not sure I understand, Your Honor. 1,000 on top of the 700 I'm currently providing every month.
I'm just asking you, based on what I'm ordering today, is that you pay $1,000. We'll come back next week and I'll decide how that all parses out and how that all fits together with everything.
Do I have a moment to check my bank accounts to see if that's something I can use?
Yeah, absolutely. Yeah, I'm not trying to order you to do something that's impossible. Given our circumstances, it seems appropriate that there be at least we move that forward. And then I'll figure out the credit for that once I've got everybody's information in front of me. And
Your Honor, I would be able to do that today if that would cover the 700 I normally cover at the start of the month for September until we hear further back.
okay, and we'll be back on the next week, which would be on the 3rd, and I'll make a determination as to how this all credits amongst everything.
Okay.
Okay.
So he needs to make a payment of $1,000 today. I'll send it over 1 week. In council, if you've got documents that I don't have, if you can make sure those go to a bench copy so that they don't get tied up in our filing system. It takes a couple of days to get through the system, and then we can proceed forward.
Thank you, Your Honor. My apologies again to council and to the court.
Thank you.
All right, so we'll come back on that one next week at 1 o'clock.
Noel McLean appearing on behalf of the petitioner, Amy Weston.
Ms. McLean is present.
Megan Bynum on behalf of the respondent, Gary Weston.
Thank you. See you there. And I believe Amy Weston is also present on Zoom. So,
Yes.
all right. So this was put over from last week. There were some filing issues. I think I have everything, at least everything that's in the court file. So if you'd like to go ahead, counsel.
Sure. This is my client, Amy Weston's motion for temporary orders. As you indicated, we were before you last week. The court did order Mr. Weston to provide a $1,000 payment, and my client acknowledges receiving that $1,000 payment. This is a midterm marriage at 13 and a half years, and the parties have 2 children, ages 11 and 16. The parties separated in November of 2023, and since then, Ms. Weston has remained the primary residential parent for the children, and Mr. Weston has essentially had the children every weekend except for 1 weekend a month. Typically, my client would have the children or has the children the last weekend of the month. And so our position is that given the fact that for the last 10 months now, these parties have exercised that visitation schedule, we think that that's appropriate to maintain given the status quo. We've outlined in my client's declaration that historically my client has been the primary parent for these children, and that she has maintained the household. She's followed Mr. Weston around the U.S. so that he could advance his career. And subsequent to their separation, for the most part, they've been able to communicate, which they should be applauded for as it relates to the children's interests and benefits. Ms. Weston has been a stay-at-home mother for the period from 2010 until February of 2024. So for the past 14 years, she's not only been the primary parent and provided for the household, but she's also essentially been outside of the workforce. Mr. Weston has now filed a proposed parenting plan that suggests that he wants a joint custody parenting plan. One, we think that that's financially motivated. 2, it's not what the parties have been exercising because of their respective work schedules. And 3, we would submit that given the history of this case, and when you look at the factors in establishing a parenting plan, clearly my client has maintained that role as the primary parent, and she's the parent more likely to continue in that primary role. Her current employment, the schedule relatively mirrors the children's schedule, and her educational goals for advancement of her own career would maintain her within a school environment, which would be consistent with the children's schedule. There has been some flexibility. Parents should be flexible, particularly if there are items or things that would be of asset for the children to be able to participate. For example, if there's family from out of town or they have an opportunity for a specific type of a trip, those things should be encouraged, and parents should be encouraged to allow their children to attend those items. And my client has allowed that. And there have been times, as she tells you, when the children have not wanted to spend any additional time with dad. For the most part, they've held to that weekend schedule, and we think that the court should maintain that. So we are asking that the court maintain that status quo, and that we provide for that within our proposed parenting plan. In regards to finances, clearly Mr. Weston has been the breadwinner for the family. Mr. Weston historically worked for Foster Farms, and he grossed about 100,000 annually. I did receive one W-2 for 2023. If you look at the tax return that was just filed by Mr. Weston, you'll note that in 2023 he grossed about $98,000. That at this juncture, I don't have the second W-2, so I don't know if there was too much or enough as far as any type of a 401k deduction. Obviously, the statute limits a threshold at $5,000 annually, and without having that, I won't know if perhaps there was excessive withholding. But nonetheless, he was at about $98,000. If you take a look at that tax return that was filed under seal, you'll note, and unfortunately the pages aren't numbered, but if you look on this, essentially the second page of the tax return where the parties would sign their tax return, it identifies their employment. And you'll note that Mr. Weston's occupation is identified as production manager, and the spouse's occupation, which is Ms. Weston, says none. And that again is consistent with the fact that through 2023, for the last 13 plus years, she's been out of the workforce. So right now, we have provided her a wage stub where she's providing on-call online teaching, and it's been very sporadic. She tells you that her current, well, as of the wage stub that we provided, she had grossed a total of $6,420 for 4 months. So that provides an actual gross of $1,739 per month. For purposes of child support, I ran her hourly at 32 hours a week, but that is a fiction. I did that for child support only. And her actual net that she has been receiving based on that wage stub would have been an average of about $1,458 per month net, where the child support calculation that we provide, shows basically an imputed net income to her of $2,354.14. My client is asking for spousal support. Again, given the length of the marriage, the parties' respective financial positions currently, and to make sure that she has sufficient income within her household to provide for herself and the children, as well as to allow her to pursue her education. The plan is for her to obtain her master's. I believe it's going to be an 18 to 24 month program. Originally, she anticipated starting in October. She's just recently been advised that that she will be starting in January of 2025. So she's back with the on-call employment then for this quarter. And during that time, she would not have income once she is in her master's program. We're still working. She's still working on the finance related to that as far as applying for scholarships, financial aid, and the like. But the plan is that with a master's, obviously that's going to put her not only with her master's degree, which would put her on the higher pay scale within the school districts, but also gives her a teaching certificate, which she technically doesn't have currently. She's on an emergency order to allow for this online current temporary employment. So based on the finances, you can see that we're relatively close in our nets for Mr. Weston. The most recent documentation I received today, they've calculated Mr. Weston's net at $9,224.47, and that includes his VA benefits of $2,658.91. I had him at about $8,900, so clearly that they've got him about $300 a month higher compared to our income. Based on my child support calculations, and assuming that the court orders the $3,000 per month spousal support, you can see from my client's financial declaration that her stated need is $7,165 per month. She currently pays rent. That does include the anticipation or expectation of schooling expenses at about $1,000 per month. But if she is able to take out student loans for that, obviously that isn't something that she would be paying immediately, particularly while she's participating in that education. The other is the insurance premiums of $1,200 per month. I note that Mr. Weston apparently has already qualified with this new employment for healthcare benefits. I'm not aware that my client has been placed on his healthcare benefits. Both my client and the children should be placed on his employer provided healthcare benefits because that's going to be a lot cheaper than the current $1,200 per month. And then I'd like to see from council that spreadsheet as far as what the breakdown of those costs between he as the employee, my client, and the children. And my client would also need to see the current insurance package as far as what's available, what's covered, and she would need insurance cards for her and the children moving forward. So we would ask that the court order that take place. Based on our calculations, if the court orders $3,000 per month spousal support, then I have child support at roughly $1,231 per month. And that would allow my client to have about $4,200 per month within her household. And that would still leave Mr. Weston with $5,000 a month within his household. So he's one person. My client is 3 people, and she would have, $800 a month less than him. The only installment debt that I'm aware of that he has at this juncture is the home, which my understanding is that he's been paying the home. And even after the home mortgage, he still has $3,800 a month for his discretionary spending, as well as his, utilities and the like. And I would suggest, given the length of this marriage, the current financial circumstances of both of these parties, that's more than appropriate to provide his wife, who has, again, supported him and traveled all around the United States for his career, so that she can meet her and the children's needs on a monthly basis. In regards to the reply declaration from Mr. Weston, in suggesting that she has the ability to work and earn her master's at the same time, my client has outlined for you her medical issues, the fact that she was not able to be employed and obtain her bachelor's at the same time. She had to devote all of her energy towards that. And again, we're talking about a short-term education, relatively short-term, when you're talking 18 to 24 months, for her to be able to get that master's, do her student teaching, and then to be able to secure employment. That's going to be a huge benefit to her moving forward. And even at that, she still will not be able, she won't be in parity with Mr. Weston's earnings that he's been able to cultivate during their marriage. So we're asking the court to order that $3,000 per month. The child support that's been requested, we technically filed this matter back on June 28th. The proposed orders that I had provided to you asked that this start August 1. It is accurate that Mr. Weston had been paying $700 per month, but clearly that doesn't even touch child support. So we're asking that the court consider the $1,700 that he's provided as far as payments prior to that time, in order that this be paid effective August 1. And then let's see. So I think that concludes my comments.
All right, thank you. Ms. Bynum?
Thank you, Your Honor. So I'm not going to go back through the background again. We're all in agreement about the length of the marriage and the 2 children. But what I do want to talk about primarily, first of all, is the fact that my client has always provided for his family, and he certainly, has no issues about continuing to do that. What he is concerned about, though, is parenting time. Even though they had this arrangement where he had them 3 weekends a month, what in fact has transpired is that approximately every other night the son is with him at his house. They work in his shop together. We have dueling declarations here, because one client is saying that the kids have represented that they want to be with her. My client's declaration says that the kids have represented that they want to be with him more. And actually, at one point, and this was covered in the declaration, there was an agreement between the parties to do a 50-50 parenting time arrangement, to such an extent that my client went out and remodeled rooms in the house, bought furniture, bought duplicate sets of clothing, anticipating that this arrangement was going to start at the beginning of the summer. He then called Mrs. Weston to find out about the pickup time, and was told that she had changed her mind and was no longer interested in that. So clearly we don't feel like there's a financial motive for him seeking to have 50-50 parenting time. He's always been involved with these kids. He feels that the kids need to have 2 active and engaged parents. Mrs. Weston points out in her declaration as support for her position that she lives in the children's school district, but so does Mr. Weston. So there's no reason that he can't also take a primary role with these kids. He has rearranged his work schedule in order to enable him to be available to parent these kids, and again, has had them quite a bit more than is being represented. Unfortunately, as to child support, as opposing counsel mentioned, there was a correction that was made to the financial declaration. There was an error that was made on our side that is to benefit of the opposing party, wherein his VA income was left out of his financial declaration. I did not discover the omission until I went to start drafting my argument this weekend. I reached out to opposing counsel and let her know that that had transpired. I also spoke to my client, and he is aware that that error was made. But because that error was made, and because Cowlitz is a messenger county, I cannot get corrected documents, at least to sort of correct the record in the court's hands today. And I'm going to have to just kind of walk you through the math. But again, this actually increases my client's obligation, so it's not prejudicial to the opposing party. Essentially what happened is that he has an additional $2,659 a month, which is his VA disability income. When he was working on his financial declaration, because the IRS does not treat that as income, he was not aware that that needed to be included in that document. He is now aware that it did. Not having it in there when we submitted our child support worksheets, it showed him having a support calculation of $1,419.43 a month. But with the additional income, that number actually jumps to $1,823 a month. His corrected monthly income should be reflected as $9,224 a month. That's net, whereas initially it was shown at $6,063 a month. When you take my client's expenses away from that, he has $2,432.52. His expenses did not change because we failed to include the additional income. They remain the same. He does make the mortgage payment, even though it was listed on the opposing party's financial declaration. She did not include it in her expenses, but it is listed on there, and that is an expense that my client pays. So when you take his monthly income and you subtract his expenses and you subtract the additional amount of child support, what he has left over per month is $608.44. She is requesting an additional $3,000 in maintenance, and we understand that it's because she wants to go on and pursue a master's degree. But that would leave my husband her husband, I apologize, Your Honor, that would leave my client with a significant shortfall because he only has $604 left after child support without any maintenance. In her expenses, she includes $1,500 a month for groceries and food for the three of them, even though my client also feeds them multiple meals a week, so that seems extremely high. She's included $750 a month for her attorney, even though she says in her declaration that her attorney was already paid out of her savings. And she includes $1,000 under education, books, and magazines, which again, I think opposing counsel clarified is her anticipated educational expense. So we do recognize that there's a shortfall here, but there is no possibility that he can pay $3,000 a month in spousal support so that she cannot work at all and go to school and also pay child support. And again, as opposing counsel pointed out, she has a bachelor's degree. So the issue is that she is significantly underemployed, and what she's asking for would leave my client in an insufficient funds position of $2,391 a month if he were to pay both the child support as calculated and the $3,000 in maintenance, which is absolutely not feasible. We also want to point out to the court that without a court order or any discussion with my client, the opposing party divvied up their savings account, all of which was money that had been put in there by my client. It had approximately $28,000. She took $14,000 out. Again, no court order, no discussion with him. So she also has that credited in the monies that she has gotten from him since this separation. So what we are seeking is a 50-50 parenting plan. Child support in the amount calculated with the correct income of $1,823 a month, and no maintenance in this case. Thank you, Your Honor.
Ms. McLean, response?
Just very briefly, as it relates to the numbers. So Mr. Weston's financial declaration provides for monthly expenses of a little over $5,900, so $5,902 a month. But his financial declaration includes $1,150 for children's expenses. The assumption is that's child support because he's got things such as food and clothing, and an $800 expense that I'm not certain what that is. Maybe that was his expectation on the child support amount. So if you back that out of his $5,900 in monthly expenses, that leaves him with $4,751 per month in expenses. From his income of $9,000.
Let me stop you. Where did you find that 5,900?
Page 1.
Why is that not what I had on the?
Oh, it looks like they've got a different number on page 4.
Yeah, I'm some confused there. I'm looking at the deck. I was looking at the actual listing, which shows 6792.
I didn't notice that. I didn't check that number. Sorry, bear with me.
And your client says it's 7,165.
Oh, so okay. Well, I was looking off of page 1. Sorry. Okay, so that would leave him at 5,500. Would be his expenses, not including that 1,150 amount that's listed at paragraph D. And so when you take his net, his net of the 9224, and you back out 3,000 in spousal support and 1,200 and I think it was 30. Yeah, 1,230 in child support. That leaves him with $4,994 on, what did we just say? On a 5,500, so he's $600 short. My client is still short. That's not meeting her actual need. But it puts them relatively in parity, still gives him enough money to meet his expenses. And obviously, when we're talking about supporting 2 households and 2 kids, everybody has to tighten their belts, as it were, financial belts, as it were. In regards to the issue of spousal support, obviously, we do believe that this is a spousal support case. We do believe that this is a child support case. The parties have not exercised joint custody. My client did not agree to joint custody, and that's just not been a reality. In addition, there has been no showing that there has been additional expenses for Mr. Weston relative to those issues. My client continues to provide everything for them. Furthermore, in regards to the account, the bank account, that was split equally. So both parties had the same amount. My client has paid a retainer with funds from those savings accounts, but she has an ongoing obligation under my Evergreen attorney fee contract to make monthly payments to satisfy whatever has been earned for that month. So she's going to have ongoing payments, which more than likely are going to be more than what we've allocated in her monthly expense list. So those are real figures. We're asking that the court grant the relief requested.
And Your Honor, I just don't know how we take all the children's expenses out, category D of my client's expenses, as though.
Yeah, I've already heard argument, counsel. So I guess the quandary that the court is in is I look at the total amount of income in the best light that everybody portrays it, and I'm about between $3,500 and $4,700 short of all the expenses the parties list and all the income that they have coming in. So that's the basic math problem, is there's simply not enough money to go around to cover everybody's expenses the way they're listed out. So that's the reality. It appears he's at the 9223-ish with the VA added in. She's currently, I think you said at 1,200. Is that what you had her down at?
I think it was 14. I'm sorry, bear with me. Her actual is 1,458.
Okay, so that means we're only 3,300 in the hole. So again, there's just no way to make this all work numbers wise. And I don't see anybody trying to hide the ball as far as income or anything. This is what they have available. And it simply means because they're not sharing expenses in one household that they're going to be cutting back in other places on both sides. And the kids are probably going to be cutting back some because there's just not enough money to fund each of these budgets that have been presented. I don't know what the long-term discussions about her going on to master's schooling. That's not really before me today. That's what she's proposing to do today. She does have a bachelor's degree, so she's probably significantly underemployed at this juncture, if that were to be the situation going forward. We've got an 11-year-old and a 16-year-old. Obviously, they're not cheap at those ages. So, do the easy stuff first. They're in agreement with all the personal property. It sounds like they're each going to keep what they're keeping. Given the circumstances on, and I don't recall specifically if I saw an attorney's fees request specifically.
Not on temporaries because the parties had split their savings.
Okay. So I would simply say that at this juncture that I'm not going to award fees either way on a temporary basis because they've had cash to do that. That may be something we revisit later on as this moves forward. What I am inclined to do, again, this is a case where there's both parties are saying each is a good parent, and we have, I think we're going to need to have probably a guardian ad litem appointed, given the difference of opinion as to where the parties want to be. Let's start with that. So who's next on the list?
Keith Lawrence, Amy Turnbull, and Twyla Corey.
What was the second one?
Keith Lawrence, Amy Turnbull, Twyla Corey.
Okay. Keith Lawrence, Amy Turnbull, and Twyla Corey. Did the review have issues with any of those in that order?
I would strike Keith.
Okay. And
I would have said exactly the same thing. So we're in agreement with the other two remaining. Either one's fine.
Okay, so the Amy Turnbull would be next then, so she would be appointed.
How is that for allocating fees?
I think at this juncture, well, let me talk about the finances, and then I'll come back and talk about the parenting plan issues.
Okay. And we also need to schedule dates for the 30-day review, when the GAL review, or I'm sorry, report is due, and the final GAL date. Do you
want a temporary report, or do you just want a final?
I don't think we need a temporary.
Agreed.
Okay. So 30 days out would be for the initial.
So is October 1 available?
That should be fine. I would think that's really to make sure everybody's in compliance. And then let's go 4 months out from today for final.
So do you want to have that the reports due on January 7th and then maybe do a review on January 21?
I think that makes sense. Let's do January 14th for a due date because holidays will probably gum things up a little bit. So due date on the 14th with a review on the 21st of January.
Okay, I'll prepare an order to that effect.
Okay. So what I'm going to do on a temporary basis on the finances, I'm going to order $3,000, and that's going to be designated as family support. And that'll be effective, just a second here. I'm going to make that effective for August. You would have $1,000 credit against that for August, so we would still owe $2,000 for August, and then we'd move into the next month. Obviously, that may create some cash flow challenges, so that the September, I'm not going to make that due until probably the middle of the month, simply because it's going to be cash flow wise pretty challenging. I don't know what all the cash resources are. Sure, that sounds fine.
And then are we doing that, direct deposit? Because we can't use WSSR if it's not child support.
I don't have a strong feeling one way or the other. Do you want to do a direct deposit or do you want to do it with a check?
I think they've been doing that. be wrong.
Direct deposit, and that's fine. That's simpler for everybody, probably, if that works.
Okay. All right.
Okay, and then
And the court's adopting my temporary order as far as the allocation of debts at paragraph 9 and not to
I think
dispose of assets.
it was just a house payment, is correct? House payment and taxes and insurance. I think that was, and then each responsible for their own bills going forward.
Right.
I think what I'm inclined to do, given that the parties are living in the same school district, and I'm gonna go with a 50-50 plan at this point. So it'd be like a week on, week off with a changeover on Fridays at let's say 5 o'clock, because I don't know what after school activities there might be. And then our JL can weigh in on that issue going forward. As far as a parenting plan, I don't think there's been any allegations on either side of 191, so those would not be included. The section, I list both as custodians under the custodial paragraph. And then section 14, which you've each proposed, some similar, some not so similar. I'll include the items in paragraph 14 that both parties agree to through council. So I'm not going to adopt either anything that's not specifically agreed to.
Okay.
In paragraph 14, those are all optional paragraphs. So.
All right. Is the court adopting language that both would be required to provide relocation notice?
Relocate, that's a standard requirement for relocation, yes.
And that neither would have preference given that they're both custodians?
Correct.
Okay. And so do you want the GAL to weigh in early?
I honestly don't think I need that. I think given again what everybody, the allegations in this case are not anything that raises a lot of concerns for the court. I think if something were to pop up and there were to be something that certainly could be reviewed sooner, but at this point, I think the 4 months out is sufficient.
Okay. All right.
We'll see how it works for everybody.
Is the court ordering the allocation of uninsured healthcare expenses, agreed extracurricular activities, driver's permit, education, licenses, automobile insurance for the children?
Those should just all be joint, I think.
As far as, are you adopting percentages based on the figures that you've already identified, with the 3,000 transfer to my client deducted from his net and added to hers for purposes of percentages?
Where are you?
Child support order, paragraph 22.
I'm trying to find that.
It would be the last order in the packet that, actually, I think they come to you separately. I'm not certain. If it's all one packet, it's probably the last order. It'd be page 6 of 9, and it would say child support order on the bottom.
I'm fine with the percentages, and it should be as for agreed to.
Yeah, agreed extracurricular. Obviously, uninsured medical is a joint decision anyway.
And I'm fine with the driver's permits and all that being included in there.
And then neither is to file tax returns claiming the children pending further order.
Correct. If they come to an agreement, that's fine, but otherwise we'd reserve that pending further order.
Okay, and then I think that answers my questions.
Did you have any additional? Am I missing anything? I think I got everything on this one.
No, opposing counsel was very thorough there. I don't have any further questions, Your Honor.
Okay.
And then I'm assuming counsel and I can maybe chat about holidays since those are coming up and see if we can agree on a holiday schedule.
Absolutely.
Yeah.
Okay.
I would assume they could probably go with a week on, week off, but if there's some specifics, we can certainly include those. And if we can't agree to it, I can certainly address that.
Okay. Do you want to set a presentation date, Your Honor?
How much time do you need?
I can probably get orders out to counsel hopefully by tomorrow.
Going to try for 2 weeks from today on the 17th.
That would work on my calendar.
Let me check my calendar really quickly. I'm available as well.
Okay, we'll put it on for the 17th. I will not be here the 1st or the 8th, so if we need to bump it, we could bump it 1 week or 4 weeks, so.
Well, and I guess now that if we're not going to get the orders entered for another 2 weeks, that would only give the GAL on the 30-day compliance 2 weeks. So do you want to maybe do the 30-day compliance at least on October 15th instead of the 1st?
Yeah, that probably makes sense.
Okay. And then we'll just keep the other dates that we talked about.
Yep.
Okay.
Perfect.
All right.
That
Thank you
works.
very much.
We could
All right,
probably,
thank you.
if you want to notify Ms. Turnbull, she's been appointed, she can probably at least get started understanding that. Okay.
Okay. Thank you.
Thank you.
Welcome. Have a good afternoon.
You too. Thanks.
I believe that is everything on our docket. We will adjourn.